Welcome to the 2025 New York Court of Appeals Year in Review. I'm Alex Gilbert. I'm an attorney with experience in the areas of criminal law, guardianships, family law, malpractice, and negligence. But more importantly, for this particular purpose, I have a YouTube channel where I review Court of Appeals decisions called Too Long Didn't Read New York Court of Appeals in 5 Minutes. And for the last 3 years, I've been providing presentations about the Court of Appeals decisions on a year in review basis. And on this 2025 video, you're going to see over 90 cases reviewed. Let's just get into it. Next are the tort law cases. Next is the case of DeBrino versus Rockefeller Center North. This is a tort law case about indemnification. This is a case where a general contractor was hired to prepare construction work and hired subcontractors, including electrical and carpentry. And a carpenter decided to use an electrical subcontractor's ladder and got injured as a result, and then sued the general contractor. And the general contractor then invoked indemnification, tried to make the electrical subcontractor, the one who owned the ladder, have to indemnify the general contractor for the injuries. And the subcontractor fought this. And the question before the Court of Appeals is, if there's a indemnification clause in a contracting agreement, in a construction agreement, does that require the subcontractor to indemnify the general, even if their property is being used by other subcontractors unknowingly, without permission and authority by the allegedly indemnifying party? And the answer from the Court of Appeals is it does not. That indemnification clauses are strictly construed, and it wouldn't require a subcontractor to have to indemnify the general for some other person's misuse of the sub's property. Next are the cases of Katletsky versus Cazenovia Golf Club and Galante versus Carlos. These are two tort cases involving primary assumption of the risk. In each of these two cases, the plaintiffs were struck and injured related to the sport of golf. Mr. Katletsky was participating in a golf tournament and got hit by a ball that was errantly hit from a different hole. And Ms. Galante was struck by a car in the parking lot of the golf course. Each of the golf courses then asserted the claim of the defense of primary assumption of the risk. They engaged in this activity of golf, and they assumed the risk of getting damaged. And the question to the Court of Appeals is, does that doctrine apply in these circumstances? The holding is that it does apply with respect to Katletsky, because when you're playing golf, you do assume the risk. There's primary assumption of the risk that you may get hit by a golf ball. And there's no proof of increased enhanced risk by the nature of that golf course. But as to Ms. Galante, there's no primary assumption of the risk that you're going to get hit by a car in the parking lot. That's not part of the sport of golf. And so that's a holding from the Court of Appeals. Next is the case of San Miguel versus Grimaldi. This is a tort case involving a claim for purely emotional damages. There's a previous important case from 2005, a longstanding precedent called Shepard-Mobley, which had said that a mother, could not seek purely emotional damages for injuries to the child in utero if that child is born alive. If the child winds up getting birthed and living. That's the longstanding holding from Shepard-Mobley. And this case, San Miguel versus Grimaldi, was a claim not of malpractice, which was Shepard-Mobley was. This was a claim for lack of informed consent and other malpractice as well. But the issue before the Court of Appeals was, does Shepard-Mobley continue to be the law, even where the claim is for lack of informed consent, if what's sought is purely emotional damage injury? And the holding from the Court of Appeals is that Shepard-Mobley is still good law. It applies with equal force, even if the claim is for informed consent, which is just a different version of negligence. And so Shepard-Mobley is still good law, and you cannot recover for purely emotional damages for injury to a child in utero if that child is born alive. Next is the case of Nellenbach versus Madison County. This is a tort case involving negligent training and supervision. The plaintiff in this case was Mr. Nellenbach, who, when he was a child around 11 years old, was a person in need of supervision and was put in the care and custody of the Department of Social Services, where their counselor allegedly sexually abused him for years. Ultimately, that counselor was also accused of sexually abusing several other children and was convicted, went to jail, and died in prison. And when the Child Victims Act was passed, Mr. Nellenbach took the opportunity to then sue Madison County for their negligent training and supervision of that abusive counselor. And when it came time for him to show sufficient evidence that that the county knew or should have known, had actual or constructive knowledge of the abuse, the trial court dismissed the complaint on a motion for summary judgment. And the question before the Court of Appeals was, on a Child Victims Act case like this, is that proper to dismiss it with a lack of a showing of actual or constructive knowledge by the county? And the holding from the Court of Appeals is that it is proper, even in a Child Victims Act kind of a claim for negligence, training, and supervision. You do have to show sufficient evidence, not speculation, but actual evidence of knowledge or constructive knowledge of the abuse. Next is the case of Maharaj versus City of New York. This is another tort case involving primary assumption of the risk. In this case, the plaintiff was playing cricket on a New York City paved park on the tennis court and was injured when he fell. And ultimately, the city raised the defense of primary assumption of the risk. There's a risk of falling in cricket. And the question before the Court of Appeals was, can you raise that even though they're playing cricket not on a grassy field where cricket is normally played, but on an asphalt tennis court inside of a park? And ultimately, the Court of Appeals here holds that primary assumption of the risk does apply because there's an inherent risk of tripping and falling in the game of cricket. And that's true on a grassy field, just like it is on an asphalt. And so they say it does apply, and the case is properly dismissed. Next is the case of Flanders versus Goodfellow. This is a tort case, a negligence case, a dog bite case, where the plaintiff is a postal worker who's delivering packages to the defendant's home and gets bit by the defendant's dog. The postal worker then sues in strict liability and negligence, and they're both dismissed by the trial court. The issue before the Court of Appeals here is, were those properly dismissed? And the holding by the Court of Appeals is actually a change in the law. This is a landmark case. With respect to the strict liability case, obviously under settled law, an owner of a domestic animal, if it has constructive or actual knowledge of vicious propensities of that animal, will be held strictly liable for the damage caused by that animal. So because there's material issues of fact, they reverse the dismissal of that. But as to the negligence claim, which has been dismissed by the trial court, obviously there's an important case called Bard versus Janke, which had held that while you can have negligence for almost any circumstance, with respect to a domestic animal like a dog, negligence won't lie. And the Court of Appeals explicitly overrules and reverses that longstanding decision and says you can have a negligence case even where the injury is received from a domestic animal like a dog. Next is the case of Smith versus City of New York. In this case, Smith commenced 2 false arrest complaints against the City of New York, and the city settled the second one of them. And when it settled the second one, it had the plaintiff fill out and sign a general release against the City of New York for any and all possible actions up to the time of the signing, without any exceptions. The plaintiff did not fill out or any exclusions or exceptions to that general release. And after it was signed, the city then moved to dismiss the first one, the first false arrest complaint, saying that the city was released by that general release. And the holding from the question for the Court of Appeals is, does that release actually apply to both or just the one? And the holding from the Court of Appeals is it applies to them both. The plaintiff never filled out any exclusions or exceptions. And so the general release entitles the city to dismissal of the first. Next are the tax cases. Next is the case of Matter of Dynamic Logic versus Tax Appeals Tribunal of the State of New York. And the issue in this case is a tax law case. The issue is whether the tax authority properly applied taxes to this business for information services. Dynamic Logic is a company that other companies will employ to determine how well their advertising is working. And to do that, Dynamic Logic will generate surveys and gather other data and generate individualized reports and give that to the client. But they also take that information and they put it into a database that helps them inform other clients or other reports. And so they might distribute that to other people in different methods and manners. And New York State has a tax that they apply under New York State Tax Law 1105C1. There's a tax applied to information services. And Dynamic Logic says, we're not an information service company. We are a service company that's not information because we provide an individualized custom report to each client. And New York State, if the question was, are they? And the holding from the Court of Appeals is they are an information service. First, because the first standard is whether the tax authority had a rational basis for their decision, which they did. And secondly, it's because they're reusing the information in their programs and in packets to give other clients as well, and that makes them an information service subject to the tax. Next are the property law cases. Next is the case of matter of LL 410 East 78th Street versus Division of Housing and Community Renewal. And the issue in this case, it was an Article 78 case about whether DHCR, the Division of Housing and Community Renewal, was improperly limiting the kind of amendments landlords can make to their rent stabilization roles. In this case, the landlord had previously registered an apartment 1B as temporarily exempt, and he tried to then go back and amend it to make it permanently exempt. And the DHCR said you can't do that. It's only limited to amendments are limited retroactively to ministerial things like spelling of names, things like that, not substantive changes. And ultimately, the Court of Appeals, the holding here is that they uphold DHCR's control and they give deference to DHCR's interpretation of the Rent Stabilization Code. On the case of Galob versus Mielnicki, it's an interesting set of facts. The issue in this case is whether a party who received ownership interest in real property from surrogate's court and after 25 years finds out that somebody else had a property interest in it as well, can that party assert full control of property through adverse possession, even though he wasn't aware of the other person's property interest? And the holding from the Court of Appeals is yes, adverse possession can be asserted even if the adversely possessing party was unaware of the co-tenant's property interest. Next is the case of Mantia versus New York City Department of Housing Preservation and Development. It's a property law case. The issue essentially is whether that agency had a rational basis to conclude that the plaintiff did not have succession rights to a Section 8 housing unit. Was their determination arbitrary and capricious, or was there a rational basis to conclude that succession rights had not been established? And the Court of Appeals finds that the agency did have a rational basis for its determination. Next is the case of matter of Seneca Meadows, Inc. versus Town of Seneca Falls. This is a property law case where the Town of Seneca Falls in 2016 passed a law requiring closure of the solid waste facility landfill operated by Seneca Meadows, Inc. by the end of 2025. And Seneca Meadows, Inc. then filed an Article 78 proceeding to try to stop that law, saying that the town failed to comply with the State Environmental Quality Review Act. It didn't take the necessary hard look required by that act. And the town challenged and said, you have no standing to bring this kind of a lawsuit. And the question before the Court of Appeals was primarily, does SMI have standing as the landfill owner? And the Court of Appeals said, yes, of course. A landowner has standing to challenge whether a SECRA was properly performed. Next is the case of matter of Hudson Valley Property Owners Association versus City of Kingston. And the issue in this case is first whether the City of Kingston properly declared a housing emergency, whether the survey that they submitted to the property owners was proper and reasonable, bringing it under the Emergency Tenant Protection Act. But secondly, also the issue is whether, having done that, whether the Kingston Rent Control Guidelines Board properly authorized two different guidelines, the first being authorizing a rent refund of people who overpaid, and secondly, reducing by 15% the base rent from a certain period of time. The Court of Appeals here in the holding authorized an unanimous decision, authorized everything, said that the City of Kingston's survey was proper and reasonable, and therefore it was a proper determination that there was a housing emergency, bringing it under the authority of the EPTA. And secondly, that the Kingston Guidelines or Rent Control Guidelines Board had the authority to pass those two controversial guidelines of a rent refund and also reducing the rents from a base rent of a specific time. The next case is matter of Rossbaugh versus Town of Lodi. And the issue in this case is whether an award of treble damages against the Town of Lodi for wrongfully cutting down the trees owned by the plaintiff, is that allowable or unlawful? Because they're not allowed to get punitive damages against the municipality. Does the treble damages of 861 constitute punitive damages? And the holding from the Court of Appeals is that it does, because there's a good faith exception to 861, where if you cut it down but you don't do it wrongfully, if you do it with good faith, then there's no treble damages. Then the fact that they authorize treble damages, if there's not good faith, means that it's punitive and therefore it cannot be applied against a municipality like the Town of Lodi. Next is the case of 1995 CAM LLC versus Westside Advisors. This is a real property kind of case. And in this case, essentially, there's a renter of a property along with a guarantor, and the renter surrendered the property to the landlord, and the landlord ultimately sued both the renter and the guarantor for damages after the surrender of the property back to the landlord. And the guarantor made a motion to the court to say, let me out of this. I guaranteed the rent up until the surrender, not after the surrender and the landlord already has the property. The landlord shouldn't be able to go after me on my guarantee because that's beyond the scope of what I guaranteed. And the Court of Appeals here analyzed it. It's very text-based, and they agree that the guarantor is not responsible for anything, any damages for anything happened after surrender of the property back to the landlord. Next is the case of matter of First United Methodist Church of Flushing versus the Town of Callicoon assessor. This is a property case, and the issue in this case is the application of the RPTL 420 religious exemption to taxes. In this particular case, a church bought 73 acres of rural property in Sullivan County in the town of Callicoon, and then claimed a tax exemption for religious uses. The town of Callicoon didn't care or disagreed, and then assessed them with taxes. And this was now a lawsuit in Supreme Court. And ultimately, the question before the Court of Appeals is who has the burden of showing the entitlement to the exemption and proving zoning violation. And the holding from the Court of Appeals here is that the parties seeking the tax exemption under 420A must establish it. And in this case, the church established that it was not using it for church services mostly. It was using it to grow vegetables, which it then distributed charitably in Flushing. And it's the burden on the tax assessor to show that it's a zoning violation, which they failed to do here. They just upheld what the Supreme Court found, and they said this was a proper entitlement to religious tax exemption, and the town failed to show a zoning violation. The next cases are Van Dyke versus U.S. Bank and Article 13 LLC versus Ponce de Leon Bank. These are two different cases addressed by the court this year, but they address the same question. The question is whether the Foreclosure Abuse Prevention Act, the acronym is FAPA, passed by the New York State Legislature, is that retroactive in application. In essence, the Foreclosure Abuse Prevention Act was designed to prevent borrowers from initiating serial foreclosure actions, because every time you initiate a foreclosure action, it accelerates the judgment, accelerates the time in which the borrower has to pay the debt. And there's a 6-year statute of limitations for a debt that's owed to be litigated. And so what FAPA did is it said, you're not allowed to do this over and over again. Once you file it, once you accelerate a debt, which is what a foreclosure does, you're not allowed to later on claim that you didn't actually accelerate the debt. And the question is FAPA retroactive in application? Does it apply even if the original foreclosure was 20 years ago, 2007 or 2009, as in these cases? And the holding from the Court of Appeals is it is retroactive in application. It does apply, and it's not a constitutional violation. Next is the case of Burroughs versus 7525 153rd Street. And this is a case about rent overcharge claims in the rent stabilization context. There's rent stabilization laws that prohibit landlords from overcharging rent. And there's an important case from 2020, a landmark case called Regina, that allowed for tenants to sue the landlord for illegal overcharge of rent in violation of the rent stabilization laws, and mentioned that fraudulent schemes to result in inflated rents is a grounds for such a lawsuit. And the question in this case, the issue in this case, is whether the element of reliance is a necessary element for a claim of fraudulent scheme to result in unlawfully inflated rents. And the holding from the Court of Appeals is that it is not. While Regina mentioned that particular element of fraud, the Court of Appeals here explains that justifiable reliance is not a necessary element for that kind of a claim. Next are the municipal law cases. The next case is Cuomo versus New York State Commission on Ethics and Lobbying in Government. And the issue in this case is whether the New York State Legislature constitutionally created that New York State Commission on Ethics and Lobbying in Government because it does not allow the governor to appoint or fire commissioners on that ethics watchdog agency, even though the agency itself purports to exercise executive authorities in some sense. And does that violate the separation of powers? Ultimately, this goes to the Court of Appeals, and the holding is that it does not. They say, Judge Rivera, writing for the majority, says it comes very close to surpassing, or very close to the boundaries of what's allowed by separation of powers, but it does not go over the line. And because of the needs here and the dangers of self-regulation, this is a constitutional use of authority by the legislature. It does not violate the separation of powers. It is valid and upheld. The next case is matter of PC versus Stony Brook University. And the issue in this case is whether the disciplinary hearing that took place had sufficient evidence to find that PC was responsible for violating 3 parts of the university's Code of Student Responsibility involving sexual harassment, non-consensual sexual contact, and non-consensual sexual intercourse. Ultimately, the holding from the Court of Appeals here is that they did have sufficient evidence based upon the student's text messages saying that he messed up and that he felt terrible, and that the disciplinary committee did not wrongfully note that he invoked his right to remain silent at the hearing. They didn't use it against him, but that's not the fact that a person invokes the right to remain silent at a hearing is not a bar to a person's finding of responsibility. Next is the case of Benkowski versus City of New York. And this is a municipal law case. By law, New York City is required to provide health insurance coverage to its retirees. And for the last 50 years or so, it's been providing a variety of options, but changed that to only provide one option, which is a Medicare Advantage plan. And if a person opted out of that, then they would be responsible for the difference. And while this was basically a claim for promissory estoppel, that the plaintiffs claim that the city had committed itself to providing this. And the question was, had they done that? And the Court of Appeals said they had not done that, because even though documents had indicated that had given descriptions of what the options were, they were not commitments to always provide this in the future. They were informational descriptions about what they were providing now, which was when they had the variety of options. So there's no promissory estoppel unless there's a clear, unambiguous promise to provide it going forward, as opposed to what they had here, which was a description of what they provide now. Next is the case of Hudson View Park versus Town of Fishkill. This is a municipal law case in which a developer entered into a memorandum of understanding with a town board saying, I'm going to make an application for a rezoning and to go through an environmental review. And you are agreeing as the town board to not make it a final determination on what to do with this property until the review is over. And it's going to bind this current board and its successor boards until the review is over. Ultimately, the review was not over by the time a new board came in that was opposed to the project and terminated the project. The developer then sued and said, wait a second, this is breaching the memorandum of understanding I reached with the board. And the board said, hey, that was the old board. This is the new board. And ultimately, the question before the Court of Appeals is there any power to the memorandum of understanding that it can bind a future board? And the holding from the Court of Appeals here is no. There's something called the term limits doctrine, which says that a municipality, a board, like a town board, cannot bind and limit or restrict a future board in terms of the discretion that it has. You can't say, well, you can't make a decision with this board that's going to affect the next board's ability to do what it wants to do by the citizens that elected it. And so as a result, the memorandum of understanding was unenforceable ab initio, and the developer loses. Next is the case of Gerbanova versus City of Ithaca. This is a municipal law case where it's alleged that a child touched a bollard, which is like a post, like a traffic barrier. And when he touched the traffic barrier, it fell and damaged the child's hand. The child then sued the City of Ithaca for negligence, and the city defended, saying, we have no written notice of a dangerous condition, which is required by General Municipal Law 50E4. And the plaintiff then said, well, you built it, so that's an exception. And the question before the Court of Appeals is, does 50E4 apply? Or is the fact that the City of Ithaca built the bollard, the traffic control device or protective post, does that relieve the plaintiff of that written notice requirement? And the Court of Appeals says, No, a parking lot, first of all, does fit under, it is considered a highway under General Municipal Law 50E4. You have to have written notice as a condition precedent to tort liability. And the fact that they built the bollard doesn't change the analysis. The exception only applies where the city erects, the locality erects something that's immediately a danger. And that's not the case for a traffic barrier or post or what a bollard is. The next case is matter of NYP Holdings versus New York City Police Department. And the issue in this case is whether Civil Rights Law 50A, which had previously shielded police disciplinary records from FOIL disclosures, that was repealed in 2020. And the question in this case is, did that repeal in 2020 mean that the records created before the repeal in 2018, 2017, 2016, are those records subject to FOIL disclosure under the Freedom of Information Law? Or are they protected because they were created while 50A was around? And ultimately, the Court of Appeals holding in this case is that they are not protected, that the repeal of 50A was a remedial statute meant to address a wrong, to create transparency and police oversight. And the whole point of it was to allow records of the police, even created while 50A was around, to see the light of day. So it's not protected, even if it was created while 50A was around. The repeal is retroactive. Next is the case of matter of Reclaim the Records versus New York State Department of Health. The issue in this case is whether New York State's Department of Health wrongfully responded to a FOIL request by not providing all the records that were sought under claims of privilege. Ultimately, the Court of Appeals here finds that certain information may be withheld as being privileged information, such as decedent's medical history, cause of death, location of internment, and whether they're buried or cremated or made an anatomical gift. That would constitute an unwarranted invasion of personal privacy and can be withheld, but everything else essentially must be given unless there's a specific exemption that applies. So they require DOH to provide the records from 1973 to 2017. And as to the other disputed issues, they remit for more further fact-finding about what those FOIL requests and responses have been. Next is the case of Tuckett versus State of New York. And in this particular case, Tuckett had been convicted and sentenced to prison on the testimony of his minor cousin, the minor cousin who had testified that Tuckett had sexually assaulted or abused him. That minor cousin later, 5 years later, recanted, said the defendant did not do that. And ultimately, the defendant got out of prison and sued the state under Court of Claims Act 8B, seeking a recovery of damages. In the burden of that claim, he has to prove by his innocence by clear and convincing evidence. The Court of Claims denied that relief, did not find the recantation credible. And the issue in this case is whether the Court of Claims applied the improper burden about recantation. Did they rely upon evidence outside the record? And the holding by the Court of Appeals here is that they affirm the Court of Claims' decision denying relief. They say that the Court of Claims did not apply an improper burden with respect to the recantation. They say the Court of Claims is allowed to take judicial notice of previous proceedings, which they did. They didn't utilize improper evidence to anyone's detriment, and they uphold the determination that the defendant failed to meet his burden of proof that he is innocent by clear and convincing evidence. Next is the case of New York Civil Liberties Union versus City of Rochester, and this relates to disciplinary records of law enforcement and the Freedom of Information Law, otherwise known as FOIL. Until 2020, there was basically a blanket exemption of disciplinary records that were exempted from public disclosure under FOIL. But in 2020, they repealed 50A, which then took away that blanket exception. And the question here is does the personal privacy exemption provide a basis to allow law enforcement records to be blanket exempt, even though 50A has been repealed? And the answer from the Court of Appeals is no. That law enforcement agencies, if they receive a FOIL request, must do the work of determining whether the records sought would be an infringement of personal privacy or not, and disclose it if it wouldn't. Next is the case of New York Civil Liberties Union versus New York State Office of Court Administration, and in this case, there was a leaked memo allegedly from the Office of Court Administration telling judges its interpretation of a specific law or court decision, and the NYCLU sought to have the documents from the OCA turned over related to that leak, and they were denied that by the Office of Court Administration. And the issue before the Court of Appeals is whether there can be a blanket denial of a response based upon attorney-client privilege. And the answer from the Court of Appeals is no. You have to specifically articulate why each individual set of documents is covered by the attorney-client privilege. There's no blanket exemption in this particular case. Next is the case of Wagner versus New York City Department of Education. And this case deals with the sufficiency of a request under the Freedom of Information Law. In this case, the petitioner submitted a FOIL request for all emails between the Department of Education and a specific domain name. And the Department of Education denied it, saying that the request was not specific enough because they could not locate the information with reasonable efforts. And the Court of Appeals reversed this, said they were conflating issues, that there's two different issues that are separate. One is the request sufficiently specific that a search can be undertaken? And the second question is, are reasonable efforts undertaken to find that material? You can't say that the first one is not specific because the second one can't be found easily. That's not how that works. Next are the criminal law cases. The next case is People versus Brisman. And the issue in this case is whether the appellate division has the authority to review and ultimately reduce a sentence as being unduly harsh and severe in the absence of a finding that the trial court abused its discretion or there are extraordinary circumstances. The question is basically, does the court have to basically give deference to the trial court sentencing and only amend reducing it if it's found that it was an abuse of discretion or extraordinary circumstances exist? And the finding of the Court of Appeals here is no. The appellate division has broad plenary authority with respect to sentencing and does not have to only use that kind of authority upon a showing or a finding by them that the trial court abuses discretion or there's some extraordinary circumstance in the case. Next is the case of People versus Clark. And in this case, the defendant was alleged to have committed a daytime robbery, and the passenger in that car viewed a photo array, which ultimately led to the passenger identifying the defendant at trial. The court denied an application by the defense to not permit the identification as a matter of law being unreliable, and also denied the application for the jury to get a special photo array charge. The issue is whether those were error, and the holding by the Court of Appeals is that they were not. The in-court identification was fine. It was a valid line of reasoning, connects the identification in court to the defendant's guilt, and it was not error to deprive the defense of a special photo array charge. Next is the case of People versus Johnson. This is a criminal case where the defendant had pled guilty to attempted criminal possession of a weapon in the second degree. And as part of that plea, he executed a waiver of right to appeal. He now appeals, claiming that the New York firearm licensing scheme was unconstitutional based upon a United States Supreme Court case, which is New York State Rifle and Pistol Association versus Bruin. And the question before the Court of Appeals is, does the waiver of right to appeal that he executed make it impossible for him to execute this appeal now, saying that it's unconstitutional? The scheme is unconstitutional. And the Court of Appeals holds no, he's allowed to make this constitutionality challenge, but he fails in that constitutional challenge. He fails to satisfy the requirements of a facial challenge as well. Next is the case of People versus Layton. It's a criminal law case. And this is a case where a 911 anonymous caller claimed that he'd been shot by a person who was in a specific kind of a car at a specific area of the Bronx. The police then stop a car that matches the description within a minute, and ultimately they recover a gun from that car. There's a motion to suppress, and the question before the Court of Appeals here is what standard must be applied to determine whether the police have reasonable suspicion to stop an automobile based upon a 911 call that's anonymous. The Court of Appeals, in their holding, they go through the Aguilar-Spinelli basis of knowledge and reliability test. But ultimately, the test right now is totality of the circumstances they identify. And under the totality of the circumstances, is there reasonable suspicion? And here there was reasonable suspicion based upon that totality of the circumstances to stop the car. Next is the case of People versus Wiggins, a criminal case, which is a murder case. And ultimately, what happened in this case is a juror note was received indicating that one of the jurors had racial bias. The judge conducted a limited inquiry of the affected jurors and denied an application for mistrial. And the question before the Court of Appeals was it error for the judge to deny the mistrial? And the Court of Appeals ultimately held it was not error. The judge conducted an appropriate inquiry a required inquiry based upon the allegations of racial bias, but the decision to deny the application for mistrial was valid and not disturbed. Next is a case of People versus Cleveland. And in this case, the police saw a defendant get out of a car with his hands clenched and thought he might attack a woman who'd thrown a bottle at his car. But then the defendant saw the police and then ran away. The police then pursued the defendant and ultimately arrested him and recovered drugs that he had discarded. The question and the issue before this court, before the Court of Appeals here, is the fact that the initial concern for the police was the possible assault of this woman by the defendant, and the fact that the defendant ran away, thereby eliminating that as a possible crime that might happen. Does that eliminate the ability for the police to pursue the defendant after reasonable suspicion had existed only with respect to the assault? And the holding from the Court of Appeals is that it does not. Flight from a level 3 encounter based upon reasonable suspicion justifies pursuit, even if the initial reasonable suspicion was of an assault and that fear has dissipated. Once the police have level 3, reasonable cause to believe a crime may be committed, the defendant's flight justifies the police pursuing even if the original cause is dissipated. The next case is People versus Farrell. And in this case, the prosecution charged the defendant with animal cruelty under Agriculture and Markets Law 353. Part of the misdemeanor complaint in this case was that the dog, Mowgli, had a mass by his heart and a mass by his spine, but the complaint never specified that it was visible to the naked eye, or alternatively, that a veterinarian had examined the dog and made that expert conclusion, or examined it and saw that under some kind of test results. And the issue in this case is whether a complaint charging that offense, but that does not specify how the officer knows that there's a mass by his heart and a mass by his spine, is legally sufficient, or is that a factual hearsay statement that would not be allowed under the charging laws? And ultimately, the holding by the Court of Appeals is that that kind of statement must be first person, cannot be hearsay, and has to explain how the mass by the heart and the mass by the spine was identified by non-hearsay allegations. The next case is People versus Fredericks, and the issue in this case is whether the complaints by the defendant about his assigned counsel were factual and specific and serious enough to warrant a minimal inquiry by the court about whether substitution was required, and secondly, whether defense counsel's response to those complaints put him in an actual conflict situation with his client such that substitution was required. It's very fact-based, so if this is an area of interest to you, you should read the case. Ultimately, the holding from the Court of Appeals is that the complaints made by the defendant in this case were not serious and specific and factual enough to warrant a minimal inquiry. In any event, they say the court did conduct a minimal inquiry, even if it wasn't enough, but they say it was not enough. And with respect to the opposition and actual conflict issue, the Court of Appeals says that a lawyer is allowed to respond with their actual efforts as long as they don't take opposition, as long as they don't say the defendant's motion should be denied and he's wrong on the merits. The lawyer is allowed to respond to the court's questions about what actions and efforts they've undertaken without it being an actual conflict resulting in the need for substitution. The next case is People versus Hernandez, and the issue in this case is whether a defendant sentenced to a sentence under the Domestic Violence Survivors Justice Act, the DVSJA, which is a relatively new sentencing provision, is a sentence that includes 5 years post-release supervision legal. And in fact, the holding from the Court of Appeals here is that not only is it legal, it's required under the terms of Penal Law Section 70.45, a determinate sentence under the criminal law, under the penal law, must include a period of post-release supervision, and the default period is 5 years, and therefore a sentence that includes 5 years post-release supervision under the DVSJA is legal. Next is the case of People versus Howard, and in this case, the complaining witness gave a statement on the scene to the police officers about the defendant, implicating the defendant in the crime. At trial, the prosecution impeached their own witness with respect to one aspect of the victim's statement. And the question on appeal here is, does that legally cause the entire statement by the victim on the scene to be thrown out? And the holding from the Court of Appeals is it does not. The conviction is satisfied. The conviction is valid based upon the statements given, even though part of the victim's statement was impeached. The next case is People versus Moss. This is a case about the Sex Offender Registration Act. And the issue in this case is whether a sex offender registration hearing can utilize a previous conviction that's still on the books, but was determined by a different judge to have been coerced as unfairly obtained, and therefore not valid for a sentencing enhancement on a different case. Ultimately, the background you have to know just for this case is that if a person has a previous sex offense conviction, there's a presumptive override to level 3, even if you're a level 1 without that. And in this particular case, the defendant had a previous sex offense conviction that a different judge in a different proceeding had determined was unlawfully coerced. It was never vacated. It's still on the books, but it was never vacated. And the question is, can that form the basis, that conviction that was determined to be coerced, but still on the books, can that form the basis for an automatic override to level 3? And the answer from the Court of Appeals is yes, it can. The question is not whether a previous conviction was coerced or not. The question is does the defendant have a previous conviction for a sex offense? Next is the case of People versus Padilla-Zuniga. And in this case, the defendant was charged with VTL 1192, which is drunk driving, and VTL 511, which is aggravated unlicensed operation of a motor vehicle. And at the time of his plea, he was not informed by the court that two of those counts, the VTL 1192 and the VTL 511, involved mandatory fines. But he was told that at the time of his sentence. He appealed and tried to get his plea back because on the basis that he was not properly informed of all the components of his sentence, in particular, the mandatory fine aspect. The Court of Appeals holding here is they gave him his plea back. They said that's an important part. He was not properly informed of all the components of his sentence, in particular, his mandatory fines. So he did not have a knowing, intelligent, and voluntary plea, and so they give the plea back. The next case is People versus Santos, and the issue in this case is whether a plea agreement that involves the defendant waiving his right to apply for the shock program is a legal sentence, or is that an illegal encroachment upon the Department of Corrections' ability to rehabilitate their clientele. And the holding in this case is that it is not an illegal component of the sentence. In fact, it's not part of the sentence at all. It's not on the sentence and commit. It's just a separate agreement between the district attorney's office and the defendant that the defendant shall not take the affirmative act of applying for the shock waiver. No one is put into the shock waiver by docs without their asking for it. And the agreement between the DA's office and the defendant, the shock waiver, is that the defendant will not apply to participate in that program. So it is upheld. It is upheld as not being a part of the sentence at all. Next is the case of People versus Scott. And in this case, the court repeatedly told the defendant he was facing up to 45 years in jail for the 3 burglaries he was facing, even though statutorily he was only facing up to 20 years in jail. The defendant pled guilty, agreeing to a term of incarceration of 6 to 8 years, and he appealed, saying that his plea was not knowing, intelligent, and voluntary. The issue is, does the fact that he was informed inaccurately about his maximum exposure render his plea not the product of a knowing, intelligent, and voluntary decision? And ultimately, the holding from the Court of Appeals is that that the plea was not knowing, intelligent, and voluntary, because an essential component of what he had to understand and know was his exposure. The very fact that he was being told something inaccurate about that exposure rendered the plea defective. The next case is People versus Williams. And the issue in this case is whether a defective statement of readiness filed by the people asserting and attesting to the fact that all the counts in the accusatory instrument are facially sufficient, if that's incorrect as to one count, but the rest of the counts are facially sufficient, what's the remedy? Is the remedy that the entire accusatory instrument gets dismissed, or just the defective, insufficient count? And the holding from the Court of Appeals here is that the defective count is dismissed, not the entire accusatory instrument. So if there's several counts in an accusatory instrument and several of them are facially sufficient, but one is not, on a motion to dismiss, the remedy is the one that's not gets dismissed. The entire accusatory instrument does not get dismissed. Next is the case of People versus Willis and People versus Martinez-Fernandez. In each of these cases, the defendant was charged with aggravated unlicensed operation of a motor vehicle, which is VTL 511, an element of which is that the person, knowing or having reason to know that his license is suspended or revoked, operated a motor vehicle. But in each of these cases, the misdemeanor complaint does not specifically state that the defendant knew or had reason to know that he operated a motor vehicle while his license is suspended. The issue is, are those complaints sufficient in light of what the statute says under VTL 511? And the holding by the Court of Appeals is that the factual sections of those misdemeanor accusatory instruments were sufficient because they state the officer saw the defendant operating the motor vehicle. The officer conducted a computer check of the DMV record showing that it was suspended, and that the face of the summons said that it could be suspended. So those factual elements which were in the misdemeanor complaint made it sufficient. Next is the case of People versus Sin, and in this case, it's a sexual assault prosecution, and it's alleged that the defendant previously sexually assaulted other members of the victim's same family in the same house. And the defendant moved to preclude that information. The judge let it in, and the question here is that are those other sexual assaults that are alleged admissible, or would allowing them in violate the defendant's right to a fair trial? Ultimately, the holding from the Court of Appeals is that because the defense in Sin was consent, it wasn't that it didn't happen at all, but it was that it was consensual, the sexual encounter. Because that was the defense chosen and pursued, the other incidents were admissible to go to the defendant's intent, or possibly as a common plan or scheme under the normal mimic exceptions to the exclusion of prior bad acts. Next is the case of People versus Lewis. And in this case, the defendant said to the court that he would like to represent himself in his upcoming trial. And allegedly that came after a number of other actions the defendant had taken to delay trials, to ask for other attorneys, he took a number of actions that delayed the actual trial itself. And when the judge denied the defendant's request to have a new lawyer and didn't even undertake a searching inquiry, did that deprive the defendant of his constitutional right to represent himself? And the holding from the Court of Appeals is that it did. The defendant did give a clear and unequivocal request to represent himself, pro se, and the judge is required to conduct that searching inquiry at that time. Next is the case of People versus Hemingway. And in this case, the prosecution charged the defendant with driving while under the influence of drugs, with a person in the car, with a child in the car. But the indictment that they prepared had the wrong subsection. It had driving while impaired by alcohol. And the people then moved at some point to amend the indictment to correspond to the evidence and theory they presented to the grand jury. And the judge allowed it. The question was, is that error? Is it an amendment to the subsection, the kind of amendment that's not allowed by the CPL? And the holding from the Court of Appeals is that it's a mere typographical error. It is allowed by the CPL. Next is the case of People versus Sherlock, and the issue in this case is whether a defendant has to register as a sexually violent offender in a SORA hearing. And under SORA, under 168A3, there are three different circumstances that would require a person to register as a sexually violent offender. Sub B is the important one here, and that subsection requires that a person in New York register as a sexually violent offender if they were convicted of their sexual offense in a jurisdiction that required them to register as a sexually violent offender, or as to register as a sex offender in their jurisdiction. Here, the defendant was convicted in a federal court of a sex offense, but the federal government does not have a registry. The 50 states have registries, but the federal government itself does not. And therefore, 168A3B does not apply because he didn't have to register under the federal government, which was the jurisdiction in which he was convicted. And therefore, 168A3B does not apply. He is not a sexually violent offender in New York. Next is the case of People versus Bacon. And the issue in this case is whether the defendant properly preserved a confrontation clause violation objection. In this case, the prosecution called a police officer who talked about what victims said. There was a double hearsay objection that was raised, but it was never phrased in the context of a confrontation clause violation until the trial order of dismissal motion that was made at the close of the people's case. And the question is, did that properly preserve it at the right time? And the holding from the Court of Appeals is a split decision, but the holding is that it did not, the defendant did not properly preserve the confrontation clause violation objection. At the time, it could have been corrected by the trial judge. Next is the case of People versus TP, and the issue in this case is whether the defendant had effective assistance of counsel based upon the defense counsel's failure to object during the prosecution's summation. It's alleged that the prosecutor in the summation said the defendant lied several times, misstated the evidence several times, but the defense counsel never objected to these inappropriate statements by the prosecutor. And the holding from the Court of Appeals is that that failure to object to those prosecutorial misconduct kind of claims was itself a deprivation of a fair right to trial and ineffective assistance of counsel. Next is the case of People versus Brenda W.W. And the two main issues in this case, this is about the Domestic Violence Survivors Justice Act. And the first issue is, does the appellate division have plenary authority to consider a resentence under the DVSJA, or do they have to just consider the lower court's decision on that on abuse of discretion? And the holding there is that they have plenary authority. They can do it de novo, essentially. And the second question is, does a resentence under the DVSJA require a period of post-release supervision as everything else is required under general CPL provisions? And the holding is yes, it does. The general rules about requiring post-release supervision still apply even in a Domestic Violence Survivors Justice Act reduced sentence situation. Next is the case of People versus Angela V.V. And the issue in this case is whether the trial court and the appellate division properly denied a resentencing under the Domestic Violence Survivors Justice Act, the DVSJA. It's a three-part test, the DVSJA, and the appellate division and trial court found that the defendant had not, the evidence was insufficient on a couple of those prongs to establish the defendant's burden. And the Court of Appeals essentially upheld that finding, said there was record support. It's very fact-specific. So if you have a DVSJA resentence case, you should read this case. Next is the case of People versus McGinley-Liddy. In this case, the issue is whether a judge's bail determination is sufficient if the judge doesn't get into the specifics as to why the judge determined bail as the judge did. In this case, the defendant had been convicted of an offense, had appealed the conviction, and the conviction was vacated and a retrial was ordered. At that point, the defendant made a bail application and the judge basically just ordered bail, but didn't explain the rationale, the reasons, the risk of flight, any of those factors required by CPL 510. And the issue and the question here before the Court of Appeals is, does the failure of the court to put into the record the thinking as to why bail was required invalidate that bail determination? And the holding from the Court of Appeals is that it does. If a judge orders bail under CPL 510 now, the judge must explain the rationale and the reasons for that determination. Next is the case of People versus Imperati. This is kind of a weird case where the issue is whether the crime of making a terroristic threat is a bail-eligible qualifying offense under CPL 510. CPL 510 specifically lists all the offenses under 70.02 as being qualifying offenses. Making a terroristic threat is in 70.02, but under the actual statute of 510.10 sub 4, it is not included as a bail-eligible qualifying offense. And the Court of Appeals, in analyzing that discrepancy, says that making a terroristic threat is, in fact, a qualifying offense. Next is the case of People versus Baldner. And the issue in this case is basically a legal sufficiency case for evidence presented to the grand jury on the case on a charge for murder under the depraved indifference to human life theory. And ultimately, the question is the evidence presented to the grand jury indicating that police officers basically allegedly struck the defendant multiple times with their vehicles into the defendant's vehicle sufficient for a charge requiring depraved indifference to human life? And the Court of Appeals says it is legally sufficient and meets that burden. Next is the case of People versus Salas, and the issue in this case is whether a missing trial transcript related to how the judge handled a jury note, does the fact that transcript is missing from the court reporter, is that constitute an ORAMA error that would require a reversal of the conviction? And the holding from the Court of Appeals is that it does not. The proper remedy is a reconstruction hearing, not just automatic reversal for the lack of a trial transcript under ORAMA. Next is the case of People versus Tapia. And the issue in this case is whether a probable cause for arrest can be found even when the police do not specifically see a quote-unquote telltale sign of a narcotics transaction. They don't see the drugs and they don't see money change hands. In the absence of that telltale sign, can there still be probable cause? And the holding from the Court of Appeals is that yes, there can. Based upon education, training, and experience of the police officer, they can find probable cause exists to find that the crime of a narcotics transaction has taken place or is taking place. Next is the case of People versus Everson, and the issue in this case is whether the trial court committed error by refusing to grant severance. In this particular case, while it was requested before the trial, the judge denied it for lack of specificity, the only actual grounds for severance arose during the summation, and at that time the judge denied it, saying what the lawyers say is not evidence. And the question is, was that error? And the holding from the Court of Appeals is that it was not error. It was not substantiated sufficiently before trial. And by the time it arose, it wasn't sufficiently prejudicial to require severance. Next is the case of People versus Kalara. And the issue in this case is about special prosecutors appointed under County Law 701 when there's a conflict with the actual prosecutor. And the question here is a special prosecutor appointed by the court under that county law section of 701 who fails to comply in all respects with County Law 701 in that the special prosecutor doesn't actually satisfy the residency requirement, are the actions taken by that non-conforming special prosecutor valid? Is the indictment achieved and obtained by that special prosecutor valid? Is the conviction obtained by that special prosecutor with that indictment valid? And the holding from the Court of Appeals is that it is not. The appointment was void ab initio, and therefore the grand jury indictment was invalid, and the conviction obtained on that indictment is also invalid. Next is the case of People versus Rosemarie Hernandez, and the issue is a similar one than earlier in the year. The issue here is whether a period of post-release supervision is appropriate, connected to a sentence under the Domestic Violence Survivors Justice Act, just like People versus Brenda W.W. And the holding from the Court of Appeals similarly is yes, it is. Post-release supervision is required, even with the DVSJA reduced sentence. Next is the case of People versus Lysias. And the issue in this case is whether a statement of readiness under CPL 3030 filed at 5:03 on the last day of speedy trial. So it's after court hours is over on the final day of speedy trial clock. Is that valid to stop the clock under 3030? And the holding from the Court of Appeals is that it is. Under General Construction Law 19, a day is considered, the first minute of the morning till midnight at night. And so it's filed at 5:03. That is sufficient. It's filed on the last day, but it's filed during the day. Next is the case of People versus Smith, which is a criminal law case where the defendant was accused of committing a robbery with what appeared to be a Glock 19 gun. Ultimately, a search warrant on the defendant's property revealed that the defendant had a BB gun, and the defendant at trial requested an affirmative jury charge that he was not guilty of robbery in the first degree, because he did not have a loaded weapon from which a shot readily capable of producing death or other serious physical injury could be discharged. But the judge denied that application, even though it was a BB gun. And the question before the Court of Appeals was that error, or was the defendant entitled to that affirmative defense jury charge based upon the fact that it's BB gun? The Court of Appeals here holds that when someone is seeking an affirmative defense, they have the burden, the defendant has the burden to substantiate that by a preponderance of the evidence, the entitlement to that burden, to show all the elements are there, to show that that BB gun is not a loaded weapon from which a shot readily capable of producing death or other serious physical injury could be discharged, and the defendant failed to do that here, so he was not entitled to the affirmative defense charge. Next is the case of Monahan versus Schroeder. This is a municipal law type case where Monahan had been arrested for driving while intoxicated, and at the chemical test refusal hearing, where an ALJ would determine whether to revoke or suspend his license, Monahan had subpoenaed the state troopers to appear so he could cross-examine them. They didn't show up, but instead of doing the things that would be required to ensure that they did show up with subpoenas, either requesting an adjournment or requesting a court order in further support of the subpoenas, the ALJ just continued the hearing and ultimately suspended Monahan's license. He then appealed, saying that they didn't have the right to do that, even though he subpoenaed the officers. And the holding from the Court of Appeals here is that the ALJ didn't do anything wrong here. The subpoenaing party, Mr. Monahan, failed to do all the extra stuff that's required to ensure the officers do arrive. He could have asked for an adjournment. He could have asked for judicial involvement. He didn't do that, and therefore the ALJ didn't do anything wrong. Next is the case of People versus Fuentes, and the issue in this case is whether the prosecution properly filed a certificate of compliance with the discovery statute, CPL 245, when it provided certain documentation about a federal complaint, a federal civil case against the certain officers, but didn't provide every single piece of paper related to that federal complaint. And the holding from the Court of Appeals is a very interesting decision, a long decision with a dissent and a majority. But the holding from the majority is that it was a sufficient certificate of compliance. Nothing in the statute requires the prosecution to turn over every single piece of paper that tends to impeach. But as long as they turn over that information which tends to impeach, which is required by CPL 245, they have satisfied their obligation, which they did in this case. Next is the case of People versus Robinson, and the issue in this case is whether a person who is handcuffed in the middle of Times Square by several uniformed police officers and asked questions about what happened over the course of about 8 minutes, and then ultimately admits that he punched the victim. Is that custodial interrogation that's subject to suppression, requires Miranda warnings? And the answer from the Court of Appeals is that it is. Next is the case of People versus Sargent. And the question in this case, the issue is whether the right to a 12-person criminal jury is a fundamental right that cannot be waived or forfeit, or is it the kind of right that can be forfeit or waived based upon the conduct of the defendant. In this case, it's alleged the defendant basically stalked the foreperson while the jury was deliberating. And as a result, that foreperson was struck, and the judge allowed the 11-person jury to continue deliberating and ultimately convicted the defendant with a jury of 11, not the 12. And ultimately, the Court of Appeals holding here is that it is a right that can be forfeit and was forfeit here by the egregious conduct of the defendant to tamper with the jury. Next is the case of People versus Wright, and the issue in this case is whether it's the defendant or the defense counsel that has the right to controvert a felony predicate statement that would result in enhanced sentencing. In this particular case, the defense counsel said he didn't have any objection to the predicate felony statement that was given, alleging the defendant was a predicate felon. But the defendant did. The actual defendant said, I want to controvert it. Ultimately, the judge didn't want to hear from the defendant because the defense counsel already conceded that it was fine. From the Court of Appeals, the holding is that it's the defendant's right to controvert, not the defense counsel's. In fact, it's the defendant that must be given the statement and must be asked whether he has anything to say in contravention of the predicate felony statement. It's not the defense counsel's right to give an answer to that question. Next are the insurance law cases. Next is the case of Hobish versus AXA Equitable Life Insurance. The issue in this case is about the recoverability of damages for a claim of breach of contract for a life insurance policy. The issue in this case comes down to an 82-year-old person obtained a $2 million death benefit policy, and a decade later, the person was still alive, and the insurance company jacked up the cost significantly, allegedly, of that insurance policy. Instead of continuing to pay that increased premium and then sue for breach of contract, the holder of the policy surrendered the policy and then also sued for breach of contract, seeking the full death benefit and punitive damages. And the issue before the Court of Appeals is, can you pursue the full death benefit if you've surrendered the policy? And the Court of Appeals says no. Surrendering is a decision you can make under the terms of the policy. And once you surrender, you can't get the full death benefit minus surrender value as damages. And there also is a cap on the punitive damages or damages under General Business Law 349 that are also eligible for any kind of claim like this. Next is the case of Geico versus Mazenberg. This is an insurance law case where Geico sought to not make no-fault benefits claim payments to a provider who was engaged in an alleged kickback scheme where he was paying for patient referrals. The question before the Court of Appeals is that permissible? And the holding from the Court of Appeals here is no. The regulations indicate that payments must be paid unless it's a foundational licensing requirement necessary to perform healthcare services that's missing. If it's a license eligibility issue, then no, you don't have to pay the no-fault benefits claims. But here, malpractice or misconduct is not the same thing as a license eligibility issue. And so Geico must pay those no-fault benefits claims. Next are the healthcare law cases. Next is the case of Matter of Ocean View Home for Adults versus Zucker. And this case addresses an apparent contradiction or conflict between two sets of regulations or laws. The first is that there's a New York City Department of Health regulation that prohibits adult homes with 80 or more beds from having more than 25% of those beds, of those residents, having serious mental illnesses, from admitting additional residents with mental illnesses at that time. But there's also a law, the Fair Housing Act, that prohibits discriminating against housing for people with disabilities, including mental illness. And the question before the Court of Appeals is the DOH regulation prohibiting adding more people with mental illness as people in beds by these adult homes in violation of the Fair Housing Act? And they say no. The holding is that it is not violation of the Fair Housing Act because it's based upon clinical professional judgments, medical judgments, as opposed to based upon pernicious discriminatory intent. And so the DOH regulation is not overturned. It's upheld. Next are the workers' compensation law cases. Next is the case of Schultz versus Newburgh Fire Department, and this is a workers' compensation case. It's a very complicated law and set of facts, but essentially the issue in this case is that Schultz was a firefighter who was injured on the job in 2012. Ultimately, he received payment from General Municipal. He received his full salary under General Municipal Law 207 while on the city's payroll, and then went out on retirement. Got performance of duty disability payments. And this is a case where essentially the city of Newburgh was looking to get recoupment of monies it paid during the retirement period of Schultz's retirement. And the question before the Court of Appeals is, are they entitled to get that recoupment from the state? And the answer is no, they are not. The recoupment under Workers' Compensation Law 25 and 30 allows recoupment of salary and wages paid during a disability, not money paid during a retirement. And this was paid to Schultz's retirement, not salary and wages. So they're not entitled to that recoupment from the state. Next is the case of Matter of Garcia versus World Trade Center volunteers. And this is a case about workers' compensation benefits, specifically 8A of the Workers' Compensation Law, which the legislature added to ensure that people who worked on the recovery and rescue and cleanup operations after the World Trade Center was struck down, that those people could receive benefits. And that law has been modified from time to time, including adding an extension for participants in the cleanup, for participants who would file a claim to file their claim. So the issue here in this case is whether the spouse of a person who worked on the pile doing the cleanup efforts, is that person eligible for that extension of time to file a workers' compensation claim? And the holding from the Court of Appeals is no. The legislature said participant, and that does not include the spouse of a participant. And that's the case of Matter of Garcia versus World Trade Center volunteers. Next are the several cases captioned under McLaurin versus New York City Transit Authority. These are 4 plaintiffs who filed application for workers' compensation benefits, claiming that they had psychological injuries, PTSD type injuries from working in public-facing jobs during COVID. And while the initial board, the Workers' Compensation Board, denied their application, saying that there was not an accident in this case because there was not additional stress put on them than there were to any of their coworkers. This was reversed by the appellate division. And ultimately from the Court of Appeals, the question before the Court of Appeals is, can there be an accident under workers' compensation law benefits law when a person is under the same or similar stress as their coworkers are during a pandemic like COVID-19 pandemic? And the holding from the Court of Appeals is that the board was correct. They reversed what the appellate division had done, and they say there's no accident if everyone's under the same level or similar levels of stress. Particular vulnerabilities are not relevant to the accident analysis of workers' compensation law. Next is the case of Ongst versus Family Dollar. This is a workers' compensation case. And in this case, the plaintiff was a store manager for Family Dollar in April of 2020, before face masks were required, but right in the middle of the right in the beginning of the pandemic of COVID-19. And Ongst contracted COVID and then had a stroke and sued or filed an application for workers' compensation benefits as an accidental exposure on the job, is how he got COVID. And ultimately, the Workers' Compensation Board gave that to him, and Family Dollar appealed. And the question here before the Court of Appeals is, do you have to be able to identify the specific time and place of exposure to be able to be to receive workers' compensation benefits for COVID exposure? And no, the board, the Workers' Compensation Board, is using a prevalence framework. And the claimant can satisfy the standard for accidental injury if the work environment presented an extraordinarily high risk for exposure, and there's credible evidence connecting the illness to the risk. You don't have to identify the actual time and place where someone gave you COVID. It's a prevalence concept, and that's upheld by the Court of Appeals. Next are the family law cases. Next is the case of Joshua J. versus Westchester County Department of Social Services. It's a fascinating case in the family law area. This deals with a mother who had a neglect finding with respect to her children. And so there were successive permanency hearings because the statute requires permanency hearings take place approximately every 6 months. And a decision would issue at the end of the permanency hearing that was subsequently replaced by another decision for the next permanency hearing, and so on and so on. So every time the mother appealed one of these permanency orders, it was replaced and superseded by the next permanency hearing order. And so the appellate division had dismissed some of these appeals as being moot because they were replaced by subsequent orders. The mother's position in this appeal was that there should be a mootness exception for these kinds of orders, and the Court of Appeals holding it's a very, very contentious majority in dissent here, but the majority holding is that these are still moot because there's a subsequent order that replaces the challenged orders. So the holding here is that they are moot and there's no blanket exception in this case. Next is the case of Onondaga County Department of Children and Family Services versus Beth F. This is a family law case involving termination of parental rights. In this particular case, the mother was alleged to have neglected her child. And at the neglect hearing, although mom was given an assigned counsel, that counsel told the court, I haven't met with my client and discussed surrendering parental rights of the child, and did not request an adjournment. The hearing took place. Ultimately, the attorney did request some time, was given about 5 minutes to speak to the client. The mom was then found to have neglected her child, and a dispositional hearing was held. Ultimately, the mother appealed, said, even though I was given assigned counsel, I was not given effective counsel. And the question before the Court of Appeals is the guarantee of counsel a guarantee of effective assistance of counsel? And is it ineffective assistance of counsel for the lawyer not to speak with the client before the hearing and to sort of remain mute during the hearing because he hasn't spoken to his client? And the holding from the Court of Appeals is that the right to counsel in the family court arena under like a TPR circumstance, a termination of parental rights circumstance, is a guarantee of effective assistance of counsel, not just counsel. And that in this case, mom did not receive the effective assistance of counsel because the lawyer had not spoken to her in advance of the hearing and did not sufficiently request time to discuss the situation with his client. Next is the case of KYZ versus Good Shepherd Services, another fascinating case in the family law context. In this case, the father, who is the subject of the termination of parental rights claim in this case, didn't speak English. He spoke a Chinese dialect, and the Social Services Agency did not provide the father with extra facilitation of interpretive services, did not provide the child with education in the father's language, did not attempt to provide the father with some kind of accommodation for working closer to where the child was being housed. And while the family court judge said that the Social Services Agency provided minimal but satisfactory efforts, the Court of Appeals reversed and said minimal but satisfactory is not the standard here. It's got to be diligent efforts. And did they actually perform diligent efforts to reunify the parent with the child? And they said they did not, and they reversed the termination of parental rights finding. Next are the labor law cases. Next is the case of Dordonis versus City of New York. This is a case about collective bargaining agreements. In this case, Dordonis was a New York City teacher and claimed that the collective bargaining agreement was violated and went through the entire grievance process under the collective bargaining agreement process. And after that was exhausted, he then filed an Article 78 claiming that it was improperly adjudicated. And the issue before the Court of Appeals here is, can an Article 78 be filed to review a collective bargaining agreement that's already been exhausted through all the different procedures? And the holding from the Court of Appeals is that it cannot, because a collective bargaining agreement claim is a contract. It's a contract claim. And Article 78s are not allowed to be used to review purely contract disputes, which a CBA, collective bargaining agreement claim, actually is. Next is the case of Sander versus Westchester Reformed Temple. This is a labor law case where Jesse Sander was a teacher hired by the Westchester Reformed Temple as a full-time educator for the religious school. And Sander posted something online critical of the state of Israel, and ultimately was fired by the temple. and she sued, claiming that they were discriminating against her based upon the content of her blog postings. And the Westchester Reformed Temple defended and moved to dismiss, basically saying, we are a religious institution. We have a ministerial exception to discrimination statutes. We're allowed to discriminate based upon the content of what you say because we are a religious institution. And the Court of Appeals here, the question before them was, does the ministerial exception apply? And if it does, were they allowed to terminate Ms. Sander? And the Court of Appeals says, yes, they were, because it does apply. Next is the case of Klosterman versus New York State Department of Corrections and Community Supervision. This is a labor law case involving the United States law, which is the Coronavirus Aid, Relief, and Economic Securities Act, which is the CARES Act. The CARES Act provided additional federal funding for unemployment for people who were unemployed as a result of the coronavirus pandemic. In this particular case, what happened about the CARES Act is, while they provided federal funding, they didn't define what it meant to be unemployed. They left that for the states on an individual basis to determine whether a person was actually unemployed or not, the Department of Labor of each state. In this case, there were multiple plaintiffs here who were educators for the Department of Corrections who lost out on their summer programs because of the coronavirus pandemic. They had annual salaries, but because the programs were no longer available for them to teach, they applied for unemployment benefits for the CARES Act for those summer programs. And the New York State Department of Labor denied their application, finding that they were not unemployed. They appealed this to the Court of Appeals, saying, was this error? And the Court of Appeals here says it's not error. The New York State Department of Labor defines a person is not unemployed if they have a salary, an annual salary, which these people did. So they affirm what the Department of Labor said. Next are the estate law cases. Next is the case of Carlson versus Colangelo. This is an estate law case, and the issue in this case is about an in terrorem clause, a no contest clause. This is a case where there's a will and a trust, and one of the beneficiaries under the will or trust of a certain kind of property sued the trustee for enforcement of rights under the trust and the will. And the trustee then defended and said, you violated the in terrorem clause by initiating a lawsuit. And the Court of Appeals here held that first of all, they reiterated that in terrorem clauses, no contest clauses, are strictly construed. They're against public policy. You want people to be able to litigate if there's something important to litigate. But in addition, because she was trying to vindicate the rights under the trust, not defeat the trust, not destroy the trust, this was not a violation of the in terrorem clause anyway. Next are the environmental law cases. Next is the case of Glen Oaks Village Owners versus City of New York. And this is an environmental law case. And in this case, in May of 2019, the City of New York set specific targets for greenhouse emissions requirements and limitations. And then a month later, in June of 2019, the state set different targets, not actually limits, but targets for greenhouse gas emission reductions. And the people some of the people that were affected by these city rules sued and said this field had been preempted by the state. So the question is there field preemption of greenhouse gas emissions by the state such that the local municipalities like the city are not allowed to enter that field and make different rules? And the holding from the Court of Appeals is that it is not preempted. The state law actually specifically was trying to work with other laws, made provision for other local laws to also pass greenhouse gas emission restrictions. Next are the election law cases. Next is the case of Fasella versus Adams. This is an election law case, and in this particular case, the New York City legislature passed a law that authorized certain non-U.S. citizens, including lawful permanent residents and some other specific residents, to vote in municipal elections. And this was challenged against the Constitution of New York State, specifically Article 2, Section 1 of the New York State Constitution. And the holding from the Court of Appeals is that it does violate the New York State Constitution, which limits voting, even in municipal elections, to United States citizens. Next is the case of County of Onondaga versus State of New York. It's an election law case in which New York State passed a new law in 2023 called the Even Year Election Law, which would require that localities, municipalities and counties have their elections on even years, not odd years, to coincide with state and federal elections to try to get more people to be involved in the vote. And when there was a challenge by the County of Onondaga saying this is beyond the scope of authority for New York State to tell us how to run our elections, the question is that unconstitutional use of the legislature's power? And the holding from the Court of Appeals is it is not unconstitutional. The New York State legislature does have the authority to issue that kind of a law. Next are the education law cases. Next is the case of matter of parents for educational and religious liberty in schools versus Young. And New York State has a rule that public schools provide a sufficient education to satisfy the educational neglect provisions of the education law, requiring the parents give their children between the ages of 6 and 16 sufficient education. But non-public schools have to be sufficient under the New York State education law. And the New York State education law gives the commissioner the ability to declare, given certain metrics, whether a substantially equivalent education is given by these non-public schools to public schools. And the result is that parents, if the school is found not to be substantially equivalent, the parents have to enroll their students in other programs. In this particular case, the parents were challenging that rule as being beyond the scope of the commissioner to do, because it impairs the parents' ability to decide how their children get educated. The Court of Appeals upheld the authority of the commissioner to declare schools, non-public schools, as not substantially equivalent, and said whatever parents do, it's not the commissioner's not telling parents how to educate their children. It's saying whether schools are sufficient or not. What parents do apart from that is, under the education law and under family law rules, that they have to have their children educated. So the statute is upheld and the power of the commissioner is upheld. Next is the case of Integrate NYC versus State of New York. And in this case, the plaintiffs, which is a youth-led not-for-profit, and parent groups and some individuals, sued the State of New York and the City of New York, claiming that the admissions policies, screening practices, curriculum, and staffing of the New York City Department of Education for high schools, for specialized high schools, for gifted and talented programs were discriminatory and resulted in racial segregation and inequality. And there was a motion for summary judgment saying that the complaint itself, the pleading, was insufficient because it doesn't sufficiently articulate a nexus between the claimed damage and the articulable constitutional violations mentioned. There's no connection there sufficient for pleading purposes to satisfy a claim of breach of human rights law and equal protection. And the Court of Appeals ultimately agrees that this is insufficiently pled. There is a strongly worded dissent by Judge Rivera. But this is an interesting case in terms of pleading standards for human rights law. Next are the business law cases. Next is the case of Ezra Sons versus Rudd. This is a corporate law case. And in this case, the plaintiff, Ezra Sons, Inc., is a New York corporation with a beneficial owner interest in shares of Barclays, but they're not registered in the share registry of Barclays. And Barclays is a English corporation, a corporation of the country of England. And in this case, the plaintiff brought a derivative suit claiming breach of fiduciary duty by the board of directors of Barclays. And Barclays defended by saying, you have no standing. They moved to dismiss, saying you have no standing to even bring this lawsuit under the law of England, which is true in the law of England. But under business corporations law in New York, Ezra Sons would have theoretically standing. So the question is, whose law controls? Is it the corporate law of England, where there is no standing unless you're in the corporate registry, or is it New York's law? And ultimately, the holding from the Court of Appeals here is that this is a choice of law question, and the internal affairs doctrine says that the substantive law of the place of incorporation, in this case England, governs disputes related to a corporation's internal affairs, including the ability and standing to bring a derivative action suit. So they grant the application to dismiss because there is no standing under English law. Next is the case of Cortlandt Street Recovery versus Bonderman. This is a business law case about piercing the corporate veil, in which the issue, as always in this sort of circumstances, when are the owners or investors of a business liable for the debts of the business, piercing through the corporate structure and actually holding people personally liable. And the Court of Appeals reaffirms in their holding the two-part test, which essentially is that the defendants, that the owners, investors actually have to have complete control and dominion over the actions of the business, and that the business itself, that dominion and control was used to commit a fraud or wrongdoing or perpetrate something wrongful against the plaintiff. And in this case, the summary judgment motion dismissing the case is upheld by the Court of Appeals. Next is the case of Baylor versus Kai Shing. And this is a breach of contract case where the plaintiff claims that he had a oral agreement with the Kai Shing as a defendant business. Subsequently, Kai Shing had a written LLC agreement with a merger clause saying it superseded any prior written or oral agreement and excluded anything not included in it. Then Baylor tried to sue breach of contract for that breach of that oral agreement. And the question before the Court of Appeals is, does that written merger, which was executed unilaterally by the defendant, supersede the oral agreement? And the holding from the Court of Appeals is, applying Delaware law, which is the place of incorporation, yes, the merger clause does eliminate and exclude the oral agreements that precede it. Next is the case of Gibson, Dunn, and Crutcher versus Kukis. This is a complex litigation matter in which Gibson Dunn was pursuing former clients for failing to pay legal fees and ultimately initiated a lawsuit against them. An attorney represented multiple of those clients and issued defenses accepting personal jurisdiction, making an appearance accepting personal jurisdiction on behalf of the clients. Ultimately, a default judgment was obtained. It was years of litigation. And after the default judgment was obtained, one of those defendants came up and said, wait a second, I never accepted personal jurisdiction. And when they said, yeah, you did through your lawyer, he said, well, that lawyer didn't have authority from me. And the question before the Court of Appeals is, must a hearing be held on that issue? Or is that sort of resolved by the attorney saying, well, my client has accepted, can we accept the attorney's representation that the client waived the personal jurisdiction defense? And the holding from the Court of Appeals is no, the attorney's representation is not sufficient if there's a material dispute, and you have to have a hearing on that issue first.